Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. The Queen delivered her 64th speech at the State Opening of Parliament on the 27th of May. The speech set out the government's legislative programme for the new parliamentary session. There were a number of bills announced that are of particular interest to business, including the Enterprise Bill, which, if passed, will include the creation of a small business conciliation service to help settle disputes between small and large businesses, especially over late payment practices. The EU Referendum Bill will set the terms of a new in-out referendum to be held before the end of 2017, where British people could get to decide for the first time in 40 years whether to remain in the EU. And the proposed Investigatory Powers Bill, which will look to modernise the law on communications data and, according to the government, will address the ongoing capability gaps that are severely degrading the ability of the law enforcement and intelligence agencies to combat terrorism and other serious crime. Other bills announced in the speech cover a proposed 5-year freeze on increases in VAT, income tax and national insurance contributions. The Advertising Standards Authority's investigation into a complaint against Unilever provides some useful guidance on what is acceptable for comparative advertising. In this instance, Unilever produced a TV advert for its Sure antiperspirant product, which made a direct comparison against its rival product, Nivea. The TV ad stated, "Trust the experts with our superior black and white protection, superior to Nivea against yellow stains." A bar chart titled Yellow Stain Protection showed a higher protection reading for the Sure product than for the Nivea one. The complaint centred on whether Unilever could substantiate its claims and whether it was a fair comparison. Unilever responded to the complaint by stating that the claim superior to Nivea against yellow stains was supported by laboratory and consumer testing that had proved Sure product left significantly less yellow staining on clothing than the Nivea product. The ASA, however, concluded that the first statement, "Trust the experts," and the claim that the Sure product was superior to the Nivea product in guarding against yellow stains was not sufficiently specific about what they were claiming as a competitive advantage. There was also criticism that the testing of the product on fabrics was not the same as those shown in the ads and only involved male subjects, whereas the ad had focused on a woman. This case demonstrates the need to focus on every detail in an advert to ensure that it is fair and honest. Comparative product advertising is likely to provoke complaints from the brand owners of the competitor products, so the need for a thorough review is more important in such cases. In the Employment Appeal Tribunal case of Basildon Academies versus Amadi and Fox, it was found that there was no express or implied duty on an employed tutor to report an allegation of impropriety that had been made against him by a pupil at another college where he also worked. Accordingly, his dismissal for failure to disclose that allegation was unfair. Employment contracts can often be silent on such issues, with the assumption that they will be caught by the implied employee-employer duties. This case demonstrates the importance of making anything that is considered important an express term in the contract. The case of Jinx versus London Borough of Havering raises an important point concerning TUPE legislation. In this case, the council had previously contracted with Saturn Leisure to operate an ice rink and a car park. Saturn then subcontracted the car park work to Regal Car Parks. The council terminated the contract with Saturn and took the management of the car park back in-house. The claimant in this case, who was a director of both Saturn and Regal, claimed his employment had transferred under TUPE from Regal to the council, and its refusal to take him had amounted to an unfair dismissal. The employment judge, however, struck out the claim on the basis that Regal had contracted with Saturn and not the council, and this lack of contractual relationship defeated the TUPE claim. The claimant appealed, and the EAT held the employment judge had got it wrong. A contractual relationship was not necessary for a TUPE claim to succeed. The application to strike out was remitted to the tribunal for an employment judge to determine. Two important pieces of employment legislation came into force on the 26th of May. The ban on exclusivity clauses in zero hours contracts and a significant hike in minimum wage penalties. 0 hour contracts remain lawful, but exclusivity clauses are banned. We're also expecting additional anti-avoidance measures to be enacted following concerns that some employers will try to avoid the ban by introducing 1 hour contracts on minimum pay. We do not yet know when the anti-avoidance regulations will be implemented. The maximum financial penalty for minimum wage breaches is now $20,000 per worker, whereas before the maximum penalty was $20,000 for any notice of underpayment. In the Starbucks and B-Sky-B Court of Appeal case, Starbucks and PCCW Media, who were the claimants in this case, unsuccessfully attempted to restrain B-Sky-B, the defendants, from using the Now TV brand for its pay-as-you-go service. In this case, the claimants had developed a subscription internet TV service in Hong Kong called Now TV and had established 1.2 million subscribers there. The channels are all broadcast in Mandarin or Cantonese. In addition to the subscription service, Now TV has been on the claimant's website and some programs and trailers on its YouTube channel. They have also been available on in-flight services. The claimants decided to expand the subscription services to other markets, including the UK. However, in March 2012, B-Sky-B launched a pay-as-you-go TV service called Now TV. The claimant's action to stop B-Sky-B from using the Now TV name was brought under the law of passing off. The case, however, fell down for the claimants, as although it could demonstrate that there was awareness of Now TV in the UK, this was mostly by people that had visited or had been living in Hong Kong, or from their website or from the on-demand videos on flights. Accordingly, the Court of Appeal found that although it had a reputation in the UK, it did not have goodwill, which is an essential ingredient to bring a passing off claim. Now, although this decision is consistent with a line of passing off cases, the claimants had argued that this line of authority is not reflective of how the internet has globalised business. The Court of Appeal, however, refused to move away from how similar cases had been previously decided. In a case concerning Canary Wharf Group CWG, a London property company that challenged the refusal to grant it a trademark for Canary Wharf in the classes concerning real estate and some other classes. It was rejected principally on the basis that it was not distinctive and that the trademarks that consist exclusively of a sign or indication of a geographical origin are not registrable. Now, there is guidance concerning trademarks that designate the origin of goods or services, in the case of Windsurfing Chimesea Productions and Hoover. In summary, this authority states that a geographic mark is unlikely to be registered if it is descriptive of where the goods or services are being provided. This case highlights that it is advisable to choose a non-descriptive mark which is unrelated to the goods or services in question. The Consumer Rights Act 2015 received royal assent on the 26th of March. Among other provisions, it introduced Enhanced Consumer Measures, ECMs. Now, these give public enforcers, particularly trade and standards officers, a wider scope of measures that they can apply in the civil courts. As an example, enforcers will be able to seek an order for businesses to pay consumers a redress. The Department of Business, Innovation and Skills has now published guidance which sets out how public enforcers can use the increased powers, and we've included a link to this guidance in the written version of this report. The Lee v Ashes Bakery case was probably the biggest legal news story of the month. In this case, Mr. Lee had ordered an iced cake. The graphics supplied by Mr. Lee depicted Bert and Ernie, the logo of outer space, and bore the caption "Support Gay Marriage." Ashes Bakery subsequently advised Mr. Lee that his order would not be fulfilled as they were a Christian business and therefore felt that they could not promote a campaign which they disagreed with. They offered an apology and a refund. Mr. Lee issued court proceedings on the basis that he had been the victim of discrimination in breach of the Equality Act. The judge was sympathetic with the owners given their strong personal objection to what the cake represented, but was critical of their failure to consider alternatives than simply refunding Mr. Lee's money. For example, asking a non-Christian staff member to ice the cake or subcontracting the order. The court awarded Mr. Lee damages of £500. Obviously, the bigger cost has been the negative publicity. In another case, JD Wetherspoon has been fined £24,000 for racially discriminating against 8 members of the traveller community. These cases are a good reminder that the Equality Act is not limited to employment issues, and the need to ensure there are policies and training in place to minimise the risk of such incidents. The Competition and Markets Authority, the CMA, has sent letters to a number of estate and letting agents, warning them that they may be at risk of breaching competition law. This follows an action by the CMA against an association of estate and letting agents, where 3 of its members and a newspaper publisher had agreed to restrict the advertising of fees or discounts in a local newspaper. The Financial Conduct Authority, the FCA, has now issued new rules concerning the sale of Guaranteed Asset Protection Insurance, GAP. This followed concerns identified by the FCA about the competition into this market. The new rules come into force from the 1st September and will require traders selling GAP insurance to 1. Provide customers with prescribed information to help them shop around and be more engaged when making decisions about purchasing the product, and 2. Introduce a deferral period, which means GAP insurance cannot be introduced and sold on the same day. GAP insurance has typically been sold as an add-on product, e.g. on the sale of a motor vehicle. The sale of add-on insurance products is under the spotlight by the FCA. The FCA has stated that this sales channel provides the primary product provider with a clear point of sale advantage that can restrict choice and competition for consumers. Now, in the last few days, the FCA has closed its consultation concerning 1. The ban on opt-out selling, and 2. Improving product information provision in relation to general insurance add-ons. Now, rest assured, we'll be keeping a watchful eye on developments in this area and bring you updates as they happen. Thank you for joining us for this month's Commercial Legal Bulletin. Each month we create a video, podcast and a newspaper of our news bulletin. All are available on the LexisNexis blog. So until next month, thank you and goodbye.